Hi guys, welcome back to Mama SOJ vlog. How you guys doing? If you are new here, you are welcome, and if you are returning subscriber, God bless you as you always come back to watch my video. My people no be smart, you know, and I'm not seeing a different news now they land for my table. And as the news they come, that's why they carry and come here to come share and with honor. For today's video, I'm going to watch them together with honor. All right, my people, we could go watch the video to see what really the apple for inside the video, my people.
Judgment which gave an interpretation in that manner.
Mr. Handover, another part of this matter, beyond, and thank you very much for explaining it and just detailing the fact that it's a non-issue, if I use the layman's terms. But another aspect of this matter is the fact that he might have perjured, because in his EC9 form, where he declared that he hadn't taken on voluntary citizenship of another country, he had indicated no. Could this be a matter, even though there's that question around who can prosecute, who can take up the matter, and would there be a willingness to do so in this case of a president-elect?
Well, if you did that, that is perjury. And the state is at the liberty of the state to do what? But mind you, if no action is taken before 29, of May, he will have the immunity and he cannot be prosecuted. But that perjury is not a ground of a petition, because our position is clear. The grounds of a valid petition are contained in the Constitution and the Electoral Act. And I want to point out to you that if a ground exists in the Electoral Act which is in conflict with the ground specified for qualification or disqualification in the Constitution, that of the Electoral Act will have no moment. But of course, the Electoral Act has not introduced any other ground except the grounds and requirements of qualification and disqualification contained in the Constitution. Therefore, perjury is not there, so there's nothing you can do about it. And let me also go further to the issue of criminality. The criminality specified in the Constitution relates to a period which involved dishonesty, relates to a period of 10 years, even if you are convicted in the Nigerian court or anywhere. And once you are not serving a jail term, that is, if you are serving a jail term, the 10-year grace is not applicable to you because you cannot come from prison to be a president. The Constitution says if you are serving a jail term and it's more than 10 years, you still be in a jail, you can't contest president. But if your conviction, after the conviction, 10 years has elapsed, you can still contest in the Nigerian election. Because if you go, you cannot expand anything that is specified in the Constitution that as a requirement for contesting an election of a presidential level or any election conducted by INEC. You cannot subtract anything from disqualification. That is the position of the law. When the Constitution specifies condition precedent, you cannot come and introduce another extraneous matter. It must be there. If there's a disqualification specified in the Constitution, you cannot add. So perjury is not one of the grounds there. I'll give you an instance. People were being disqualified on the ground of not paying tax. But when the matter went up to Supreme Court, or Court of Appeal in some instances, tax was not a requirement in the Constitution. Tax was not a requirement in the Constitution. All those judgments were obtained because it was not part of the Constitution. So perjury, as in this case, is a state matter. And but why I was a minister of justice, sometimes lawyers may not go to court because you don't know what the state may do. Assuming now the Attorney General say, okay, this is perjury, I'm charging you to court. trial may not take just 1 month. Before you start the trial, 2 adjournments or 1 adjournment, or before arraignment, 29th of May will come in. You, as a prosecutor, you are stuck in because there's nothing you can do. The immunity is absolute. It's not qualified. So
Okay.
the trial
Okay.
will abate.
Okay, Mr. Handover, there's a...
And let me add another thing.
Okay.
Let me add another thing.
Yes,
if
sir.
you go for trial, and tomorrow the president says, I give him pardon, there's nothing. So sometimes prosecutors will be blamed, especially the Office of Attorney General will be blamed, but we also, in the course of process, we look at the environment. Because this office operates within a difficult terrain. You are dealing with politicians, and you have gone and got a conviction on perjury. Tomorrow the president says, I have pardoned him. There's nothing you can do about it. So
Okay.
sometimes you think that initiating certain action of this nature may be futile. You may not be able
Okay.
to succeed.
Okay.
But that does not mean I say people should not follow the law.
Okay, so Mr. Adwaka, 2 things I'd like you to state. Take us through the procedures of how perjury goes. Enlighten us more for the sake of public
Well,
knowledge.
perjury-
No, secondly,
Perjury is an
no, I have not
It's
finished
a-
asking my question, sir.
Yes.
Also, I want you to talk about the pick and choose that we see in public dispensation of justice. The fact that if cases concern people that don't wield power, it is fast-tracked and accelerated. But if it concerns people that wield power, what you just said now could apply. The fact that when you even put up the case and it goes through trial can be elongated and the likes and all of that. And also, I want you to also make a clarification and distinction between public morality and the ecosystem we live in Nigeria. The fact that a top candidate that finally eventually became president-elect didn't deem it fit to make a declaration of the fact that he hitherto had another passport, which is not a big deal, which is not against the law, in his form. That's a case of public morality. I know, yes, that might not hold water in the logicality of the law, but that's a case of public morality and public perception, which you cannot discount from societal ecosystem, because you said just now that court cases also have a look and feel of societal factors.
Well, thank you very much. Certainly, the issue of morality comes in. I will not deny that fact. It's a very big burden on society.
Morality is not law.
To see we leaders appear to violate the law. But you could see there's a presumption in law of a person is judged not to be guilty until he's proven. If you say that, still until trial commences and he's convicted. I have agreed with you on the issue of the burden of morality. But I also have shown you the constitutional provision that we have to take the morality, if we have to take the morality to enforce into law, we must follow this. And the thing is that we arraign the person to court, the person take his plea, and if he says he is now guilty, then we have to bring evidence. Trial will go normally, and there will be conviction. It is expected. Speedy trial is the expectation of the whole country. But I pointed out the shortage of judges, the condition in which they live. You go to the federal high court now, or state high court, perjury is an offense that ought to be prosecuted by the police because of the recent decision of the Supreme Court. It's a state offense. Of course, that means the perjury was committed within the area of federal capital territory, so it has to go to the state high court. You go to one of the courts, you see court list 29 cases. And then cases are called based on seniority. Sometimes it's not the fault of the prosecutor. The prosecutor will be a young lawyer. He goes there with the facts, ready to prosecute. Senior counsels come in, call the case after order, because that is a procedure. If the most senior advocate will call his case, if he has 20 cases, he will finish his cases before any other person. By the time this is done, you will discover that time has lapsed, adjournment will be granted. This is occurrence as a result of inadequate staffing of the judiciary, because the manpower, judges ought not to have more than 5 cases on the court list, but you could see 29 cases. So such adjournments derail justice. And these are some of the things most of us have been advocating. Increase the number of judges for service delivery. A judge should not have more than 5 cases. Perception is there. You cannot doubt about that. Perception is there. And that is the thing that the public is complaining in everything. Mind you, when I came here on your channel before, I said something which the public has been yearning. And I say this is the time the judiciary and everybody involved in administration should look at it. Take, for instance, in the case of electoral matters. Our attitude has been to scrutinize the outcome of the result. This person scored this number. This person scored this number. And therefore, infractions that occurs are targeted on the result, who had the majority. But the main corruption that occurs in the electoral process is refusal to follow the procedure that leads to that result. And that is why at that time, that is what the public is yearning. Nobody will complain about an election if the procedure leading to those results that produce the majority result, which became the winner, and the procedure is followed. Nobody will complain. That, if you see, all the complaint has been that the procedure that's supposed to be done like this is not done. All the elections you have in the cases, the complaint may not necessarily be the overall result. But when we go to court, the target is that prove whether this result is correct or it is not, or this person scored more, forgetting that the main corruption is within the foundation which those results occurred. This is why it goes to the perception you are talking about. That is the perception that things should be done right. In criminal trial, the perception is that everybody should be equal within the law. And it...
Yeah, I just wanted to intervene.
Sorry, sir?
I wanted to intervene at this point. You brought up the issue of your last conversation with Arise News, which became controversial because you had cause to say you were misinterpreted. And I just want you to give us the opportunity for you to clarify your position with regard to 25%, whether you need it in 36 states
and
the federal capital. No, just a moment, sir. Just a moment. You know, I just want you to offer us very strong clarification. We have tried to, state what you said and to correct it. But you are here, so you have a chance. As for the issue about morality, well, with due respect, as you know, morality is not law. And so that's why the courts are always at variance with public perception, because the courts don't deal with morality. They deal with the technical details. Over to you.
Thank you. I never even in any way said morality is law. My previous interview with you also, I told you morality is not law. And I think we are all talking the same thing. Come to my interview. First, I never said some amateur ought not to be. You asked me whether there were going to be problems. And I say, yes, there will be.
My people, now the video now on a new watch finish so. On a see what the apple for inside the video. Alright, my people, I would like to end the video for you. Make una let me know what you all take for the comment section. And if you never subscribe, make una subscribe so that you don't miss any latest way I upload. On my bye till I come, I will next time. Bye guys, catch my next video. Bye guys.